Sanjoy Ghosh, let me bring you in. What do you think is going on? And if it is one nation, one election, I must ask you up front. Justice Chauhan, who headed the Law Commission in 2018, provided three options for this to happen. He said, you can either change the schedule of state, advance or postpone the elections in state assemblies, the life of a state legislative assembly. You can hold elections twice in 5 years. And he said if there's no political consensus, you can club in a given year the state assemblies and the general elections. This last point, of course, has led to wide speculation about whether the government might want to hold an early election. But on a point of law, the Law Commission also said 5 constitutional amendments would be needed. Would these constitutional amendments need the ratification of at least 50% of state assemblies, or would they not?
Well, thank you, Barkha, for having me. And with this government, it's always interesting. There's no boring moment. We are always guessing, and we are always being amazed at what they end up doing. Now, so far as the women's reservation bill is concerned, while I would be very happy if this was the case, but please keep in mind that the women's reservation bill has already been passed by the Rajya Sabha. So therefore, both houses have been summoned. So they must be up to something. Otherwise, they would simply just summon the Lok Sabha because it only requires the Lok Sabha to pass it, and then the bill can be sent to the president. Now, so far as one nation, one election, etc. are concerned, as you rightly said, that there was a trial balloon floated through the Law Commission in 2018, under the chairmanship of Justice Chauhan, and various options were thrown up in the air. One of them was that certain assemblies like Delhi and Haryana, you could bring forward the elections, and some of the assemblies like Madhya Pradesh, Rajasthan, Chhattisgarh, you extend the term or precedence rule and you have them together, or you have elections once a year. To answer your question, the Law Commission itself said that state ratification is not required, and strangely so under Article 368(2, just changing the terms of the assembly might not strictly require the assent of the states. However, since we are doing conspiracy theories, let me throw in another one. Even Justice Chauhan was cognizant, and we are all cognizant, that even in this one nation, one election thing, in a parliamentary democracy where you have a chief minister at the helm of the state and the prime minister at the helm of the nation, you have governments which will fall. So what happens if a government falls? And even Chauhan says that, if there is some time left, you have another election for the remaining period, etc. But one of the options could be, though of course the Supreme Court in Kuldeep Nair's case has said that the parliamentary system of India is part of the basic feature of the constitution. But one of the things, while we are at a conspiracy theory, why not, is toying with the idea of making India a presidential system of government and have the chief minister or replacing the governor and the prime minister replacing the president, and have that kind of a system, and that will completely change the entire dynamics of the process. Of course, that might require state ratification.
Yes. So can I ask you, because I need to correct myself, because my understanding was that to move towards simultaneous polls would need state ratification. You are saying that it would not.
No, it would not, because you see Article 368.
It's a very important point, because it suddenly makes a very complicated thing very easy to do in 5 days. So maybe we need to revisit our feelings. Sandeep, you want to brief introduction?
Sanjay, question to you. Say, one is extending the current, the tenure of current assemblies which are expiring earlier. What about if you're shortening the thing? A chief minister can turn around and say that, you are truncating my term because it's my prerogative to when to, call for the elections. They can go to court and,
Absolutely. So you're absolutely right. See, one way of doing it in old days, when the courts were very, very hesitant to interfere, would be simply to impose precedence rule in those states, right? And by the time the precedence rule issue would be settled, you would already have your one election and everything would be over. And courts would be reluctant to interfere. So you see, curtailing is not a problem. Extending is a problem, because extending requires a constitutional amendment. Curtailing is simply you can use your power.
But the moment you don't need state assembly ratification, then this is something that can be done in a 5-day session.
It can be done. It can be done.
But you see, if you try to impose precedence rule in those states which are not due for elections, it'll open another Pandora's box. Precedence rule just cannot be imposed at will.
No, He's
Yeah,
right.
sorry, sir.
In fact, as I said, and he's right. After Bombai's case and several judgments, including the latest one in Maharashtra, the courts are very, very active in inspecting what are the circumstances which went into in imposing the precedent's rule. So he's right to an extent that may require also a constitutional amendment to curtail specifically for this particular assembly. And unfortunately, my interpretation, I'm subject to correction, is that even that does not require state ratification.